Hello Legal Eagles, and welcome to Basic Negligence and Psychiatric Injury example exam questions. So I really wanted to use this video to go through what you can expect in terms of a problem scenario question, typically a sort of 30 marks question, and really go from there. Just to recap as well, though it's not explicitly mentioned in an exam question, you do need to actually ensure that you discuss any possible defences that may arise. So with dealing with tort law as we're on paper 2, which is tort law, AQA law. We've so far covered 2 defences for basic negligence, and the first one here on the left side, contributory negligence. So this is a statutory defence under the Law Reform Act, Contributory Negligence Act 1945. And the effect that it would have here is that if successfully raised by the defendant, the amount of damages that the court will award will be reduced. It recognises fault on both sides, on both parties, on the claimant as well, and possibly can be up to a 100% reduction, so can be quite effective. Defence 2 is consent. This is something that is less commonly used, but you need to be aware of it. And here you're really saying that the claimant has assumed the risk, assumed the responsibility of the risk. So there's 3 tests that have to be shown via evidence by the defendant. Firstly, knowledge of the precise risk. The second one is that there was sort of free will by the claimant. And thirdly, if we go into it, free will to accept that risk. And the effect that this will have is it's a full defence, but very important to note, it's not available to road traffic accidents according to section 149 of the Road Traffic Act 1988. So just be careful of that. If it's in a problem scenario, a road traffic incident, don't mention it. As ever, everyone, in exam questions, time is of the essence. Only refer to what's relevant in the scenario. Do not waste your time otherwise. So this is an assessment I actually did with my students. I've since given it back. I've preferred not to do it timed to begin with, because I think it's important that you just give yourself that space to actually understand the topic and how you're sort of framing it and your answer. But this covers basic negligence, which, if you recall, is duty of care, breach of that duty, and damage. In other words, you're proving causation, that the defendant caused the injury or the damage that the claimant actually suffered, and also psychiatric injury, which we're talking about primary and secondary victims. So here is a problem scenario that I've actually created myself. Very typical to what you might find for an AQA 30 marks question. So please pause this video at any point, but I'm going to read through this now. Danny works as a bus driver and is late with his schedule of picking up passengers. He approaches a set of traffic lights at a junction that are indicating amber, but instead of slowing down and stopping, he accelerates through them as they begin to turn red. Delroy is riding his bicycle to work and crosses into the path of the bus. There is a collision and Delroy suffers severe head injuries on impact. He is not wearing a crash helmet at the time. Teresa witnesses the crash as she was driving just behind Delroy's bicycle and had to swerve out of the way of the bus. She rushes to his aid, knowing it is a bad accident. On closer inspection, Teresa sees that Delroy is unconscious and there is a large amount of blood on the road from his injuries. She calls for an ambulance and Delroy is airlifted to hospital. Teresa later suffers post-traumatic stress disorder and refuses to drive again. Delroy's partner Ashley is called by the hospital and later arrives to witness Delroy in intensive care, where he is unconscious and on a ventilator while in a coma. Ashley suffers nervous shock. So the question, typically by AQA, framed as follows: consider the rights and remedies of Delroy, Teresa and Ashley against the bus driver Danny. So I'll just move us on again. One of the frequent questions I get asked by students, And this can apply to whatever unit you're studying, really, whether it's crime, problem scenarios, or tort law in this case, whatever it might be, is an approach called a mnemonic called IDEA. And I've broken it down here. So students find this really useful because if you are doing this in your answer, and I'll show you in a minute a way to make sure that you're covering all that's expected of you and you're meeting all those assessment objectives. So firstly, identify the law or topic. Secondly, you need to define where the law is found. Now, whether you're talking about, if it's crime, for example, an offence, and whether you're talking about a defence, or here in this topic, a tort and a defence, it's all similar, really. So where does it come from? A statute? Common law? Is it a case? Where most of the marks are is in the explain and apply part. So you need to explain the elements of the law that you're discussing, or indeed the defence, and then finally you need to reach a reasoned legal conclusion. You need to give your opinion as to what the outcome will be based on the law and your understanding of it. Now, common problem that most students have, particularly when they start a course, is they actually jump straight into giving an opinion. So they clearly, they can spot some of the issues, and then they say, well, in my view it wouldn't be this, or in my view it would be this, etc. You've got to make sure, particularly at A level, that you are showing knowledge and understanding of the law. You're explaining the law in detail. There is a reason why we go through a number of cases, citing them to back up and support what we're saying, and also any section numbers and so on and so forth. So that's the mnemonic, but let's look at that a little more clearly. So back to the exam problem scenario. You'll notice it's the same scenario, but I'm just focusing on the first part of it involving Danny and Delroy. Now, at this point in the exam, we should know that for basic negligence to prove that was the case, Delroy will need to establish that there was a duty of care owed by Danny to him, that there was a breach of that duty, and finally that it resulted in damage, and all three have to be met. If we don't, then the claim for Delroy will not be successful against Danny. So I'm just going to do part of this here, but if I go across, we should know already that Caparo and Dickman is the leading case for establishing a duty of care. It's still used, and there's a three-part test. Once more, we need to prove all three parts. So again, just to explain, I'm thinking, as my students ask me, the elements that we're proving is duty of care, breach and damage, but within each element there are subsequent, additional tests, and all of them have to be met. So we're just dealing with duty of care right now. So you could see this really as your first paragraph. Don't worry as well about, for problem scenarios, writing an introductory paragraph as such, because these are not essays. What I do recommend to my students, though, is that you set out, perhaps, in that first paragraph, some of the elements you're going to deal with. And I'll come on to that shortly to make that clearer. So going back into it. Was harm reasonably foreseeable? You need to mention that, explain it, and give your view as to the scenario. You then need to mention the second one, is there a close proximate relationship, and then give your opinion again, and then the same for the last one. Of course, there are cases, there's an individual case you could have for each test. For example, Kent v Griffiths, or Kent and Griffiths for the first one. But what I would say is the main case that you've got to remember for duty of care, where these three tests come from, is Caparo and Dickman. Now, some students also through their reading have picked up on Donoghue and Stevenson, the Snell and the Bottle case. That is the case from the 30s that really sort of started the whole sort of development of negligence in the law. But that is quite an old case, and really the message from the exam board AQA is that it's really not the most important case to raise anymore. So Caparo and Dickman, I say again, is the most important. Now, shifting to this, let's look at what the paragraph could look like in terms of structure if we were writing it. So here we are, here's a possible. Now I said there's no need for a particular introductory paragraph, but look at the first one. Delroy has the right to sue the bus driver Danny for basic negligence and the injuries he suffered. This is me addressing the rights part. So I use the word right. Delroy has the right to sue, and I'm identifying the topic. In the exam, you're not going to be told in a 30 marks question what area of law it's going to be on, so you have to make that judgment. Clearly here, basic negligence is the starting point. So I've identified that in the first line. This is found under common law, so this isn't statutory. These are all born from cases, Capara and Dickman being the example. So I've now defined where that law can be found. And then I go on to say, to succeed, Delroy will need to prove that Danny owed, again you can see, duty of care, breach of the duty and damage. And if successful, the court will award him damages. So there, I'm actually also linking it back to the question of remedies. What, will the claimant receive if successful? And I've mentioned damages there for the first time, so I'm going to be credited for that. There's also a useful feature for doing it that way, because when I'm in the pressure of an exam, I can look up at that paragraph and I can see like a map ahead of me what I need to discuss. I need to talk about duty of care. That's going to be my first paragraph. I need to talk about breach of duty. That could be my second paragraph, and so on. So looking at the next paragraph, the beginning really of it, I've put, to prove Danny owed Delroy a duty of care, the case of Capara and Dickman established 3 tests. And then you can see from there, all I'm doing is I am referring to test 1 and then giving my opinion, referring to the next test, giving my opinion. It's what we call the explain apply approach. So here it is again on the next screen, but I've color coded it according to that IDEA idea mnemonic. And I'm sorry if the colors don't quite show up as well as perhaps on the screen for some, but you can see there, identify. The first sentence in red does that as I described. The second one in green, where's the law coming from? It explains that. And then the blue part, which is always going to be more substantial, is you explaining the law. And you can see that you're doing that, for example, when you raise that case and you're mentioning those tests. So the apply bit can vary when you're giving your legal opinion. But here, because the tests are quite snappy, we've got there, therefore Danny going through a red light and putting other people in danger meets this. So that would be sufficient for that. And you notice afterwards that you've actually covered all parts. Now, one useful thing, once you've written your problem scenario answer, if you grab a different highlighter color for each part and then search through your answer and see if you can actually identify all these parts, all these colors. If you do, you know you're doing it correctly. Moving on, this is now the second half of the problem scenario. So this is dealing with psychiatric injury with Teresa, and then moving on to Ashley. What you need to identify here is primary victim, secondary victim. They're the only 2 types of claim that will potentially succeed. And you need to be able to define both of these in your answer. So whatever each person may be, the starting point is to explain and define what these 2 are. And then you narrow it down to who you're talking about. So for primary victims, clearly Teresa is going to be a primary victim. Now if you look back over your notes, it will be because she is directly involved in the accident, and furthermore, and a lot of people miss this, so you've got to be careful, got to go line by line. If you read it again, do you notice that it says that she had to swerve out of the way of the bus that Danny was driving? The implication there is that she herself would have been, injured. So that's what makes her a primary victim. As the mark schemes say, she is within that zone of danger herself. Now, in terms of Ashley, finally, she wasn't at the scene. She wasn't at risk herself, so she'll have to make a claim as a secondary victim, and whether or not she succeeds will depend on the Alcott case and the 4 tests that came out of that for her being a secondary victim. Now remember here, that from the test point of view you have, close ties of love and affection being the first. Was mental injury suffered at the scene? Well, no, it wasn't. Or in the immediate aftermath. So that's really where Ashley comes into play. You would be also citing perhaps the McLaughlin and O'Brien case, because the law's been quite fair here to recognise that if a loved one is told that, for example, their family's been in a terrible accident, as was in the McLaughlin case, and that person rushes to the hospital, and then having witnessed their loved ones in distress at the hospital and suffers a psychiatric injury, and by the way, nervous shock, the examiner often likes to term it that way, that is a recognised psychiatric condition, then that would meet the immediate aftermath part of the test as well. Is it through their own unaided senses? Well, Ashley sees her partner at the hospital in distress, so yes. It's if it had been that she had been told by somebody that her partner was in hospital, then that test would have failed and her claim would have failed. And then lastly, the reasonable fortitude test. Would a person of reasonable fortitude have suffered mental injury similar to Ashley in those circumstances? I think everyone would agree that in those circumstances, seeing their loved one in such a terrible state, the answer would be yes. So on face value, it looks like Ashley's claim for a secondary victim will succeed. So finally, the examiner will read through your answer and then try to place it in a band. This is for AQA specification, depending on its content. So I've actually taken that table. I want to show that to you now. This is something I'm trying to get my students to do as well. So if you look, starting at the bottom, you've got band 1, marks 1 to 6, the least amount. I've actually cut off 0 marks, which would be no grade at all. But if you work your way up to the top for a 30 marks question, you get to band 5, and that's minimum of 25 marks, at most 30. And you can see the breakdown at the top of the assessment objectives, how they're kind of weighted in terms of knowledge, understanding, analysis, application, and so on. Now, these descriptors are, slightly different from one another. So, for example, if you start at the bottom, it says knowledge is minimal, and it uses the word minimal quite a lot. You go to the next band at 2, and it says limited. You go to the next band at 3, and it says satisfactory, and it's building and building, so much so that you're kind of developing the arguments. The mark scheme will also say the key content that you should have. So for this exam answer I've shown you, you have to discuss basic negligence for Danny in respect of Delroy. You have to discuss any possible defences. So for example, contributory negligence would have been relevant because Delroy did not wear a safety helmet on his bicycle, and so therefore the argument could be he's at fault and the injury he suffered is substantially worse because he hadn't been wearing his helmet. So you'd have to cover that. And then we talked about psychiatric injury in respect of Teresa and Ashley and making sure they're correctly identified. So that would be a perfect answer if there is such a thing. But we go our way up. We've got 19 out of 24, band 4, which is good. So you can also see it makes mention there of, good analysis, good legal argument, use of cases or legal authority as it's called. So if you've covered all the elements, perhaps except for the defence, and you've done that reasonably well, you could put yourself in band 4. If you've also covered the defence and your answer is quite detailed and it's using, a supporting case, at least one supporting case for each element that you raise, remember, duty of care, breach, and so on, then that very well could find itself in band 5. So try and get used to placing your answer into one of these bands, and you get a greater idea of how the examiners work. So that was the task for my students. I'm going to leave that there and just simply say thank you very much for watching. If you have any comments, please do place them down below. Bye for now.